Thank you, Mr. Chairman. Thanks to all of you. I'm never confused for Senator Merkley or Markey, although just now someone could be confused, because I think what you're hearing from the two sides of the dais get right to your point, Governor Gordon, of we have to find balance, identify scope and creep, and I think we're all trying to do exactly that, find balance. What is that balance between a state's right to its own environmental protections and its resources, and the state's rights to access to interstate commerce and global commerce? And I come from North Dakota, a state like yours, where we are landlocked, right in the center of the North American continent, and are rich in resources that the country and the world wants and needs. And so striking the balance, I think, is what the bill does. One of the things that strikes me, and I'm just going to opine for a minute, because listening to all this has been fascinating and encouraging. I hope people watching it are encouraged to see an intellectual discussion of peers and experts about what's the right balance, because I'm encouraged by it. But when Congress isn't very prescriptive, it allows the bureaucracy to write the rules. And that almost never turns out well, from my perspective, and doesn't protect states' rights either to, to regulate themselves or their resources, nor to interstate commerce. So I appreciate us coming back to the scope of 401, what that means, what that section provides in terms of clarity or lack thereof and authority. So with regard, I want to get back to the Millennium Project, because I think it's an interesting one, because it's similar to issues that we in North Dakota have had with the state of Washington's zeal, if you will. So in regards to the Millennium Project, the state of Washington denied the 401 permit despite the state's own EIS, which stated, quote, "there would be no unavoidable and significant adverse environmental impacts on water quality," unquote. That's the state's EIS. So it's not a surprise, in my view, considering that the proposed terminal is only a few miles from the existing port of Longview, and that moves millions of tons of cargo, as you know, each year. But I found it interesting the state of Washington proceeded to deny the water quality certification under Section 401 for 9 reasons that had nothing to do with water quality. Doesn't mention water. In some of them, it's a very far stretch. So, governors, both of you oversee DEQs. You've spoken a little bit to this, but when you get a DEQ permit, and of course you have great experience in this, or 401 permit application, do you consider a lot of things outside of water quality? And maybe start with you, Governor Stitt, since you have the background in this.
Well, we look at, there's endangered species, we look at that, we look at the groundwater, we look at any kind of impact, we look at the maps, we look at the scope of the project, we make sure that it complies with the Clean Water Act and our own state water standards, but we keep it to, we don't try to play, pick winners and losers, we try to keep with the Clean Water Act and move it forward. And like I said, we do that in 60 days. So putting parameters of 1 year, we think is very reasonable to bring the scope, which you said very well, back to the real issue of 401, which is water quality in a state.
Governor Gordon, could you opine?
Mr. Chairman, Senator Cramer, I think you're absolutely on point. As I was thinking about this and a similar opportunity that Wyoming might be presented with. Wyoming is the home of the largest wind farm in the country. That wind farm is going to require a stormwater quality permit. The customers for that wind farm are going to be all over the Southwest and including Oregon. If we were to fancifully apply 401 as Washington did, we might deny a stormwater quality permit with prejudice for the wind farm, with the idea of saying that we're not going to supply customers in the West. Of course, we wouldn't do that, because we would work with the proponents of the wind farm to make sure that the water quality impacts were addressed, only the water quality impacts.
With regard to moving oil, for example, Governor Stitt, North Dakota, of course, is the second largest oil-producing state in the country, further from markets even than Oklahoma. But your neighbors, your port neighbors include Texas and Louisiana. Do you see a difference in how they apply 401 to, say, a state like Washington or Oregon that may apply it differently? And does it make sense that we'd have a little more of a uniform application?
Well, we believe so. I mean, obviously, there's pipelines running through Oklahoma from your state down to our state. We are the southern leg of the Keystone. We have access to Louisiana. We're building natural gas pipelines to transport LNG down to the ports in Louisiana. We obviously have direct access to the Houston refineries. And so I think Texas, Louisiana are interpreting the rule properly. Their water is, they're following their water standards just like we ask every state to do. This is really about making sure that we don't let certain states politicize this issue for their own biases and then, harm the assets of one state. That's really what it's about.
We think of it as weaponizing. Thank you, Mr. Chairman.